So there's a lot of words on this page, and there's a method to the madness. I promise that I feel like it's very important that we're looking at the Kentucky Revised Statutes and any regulations that I give you the accurate information verbatim so that you can see for yourself what it says. I think we have pretty decent and good language in our guardianship statutes and regulations that really promote the principles of supported decision making, quite frankly. I don't know that they are practiced. I was in a room yesterday and I presented to about 100 members, 100 individuals at a provider conference on guardianship. And when I talked about absolute power equals guardianship, and I asked them, have you known any guardian that felt that their role was to be absolute power? Almost every one of their hands rose. So that's why I feel like sharing this information in these trainings is so imperative so that we're all educated, because many of you all are either parents, you're providers, you're persons who have a disability. You may be advocating for yourself or for others. And I feel like this language is important to educate you so that you can educate others and advocate for others and empower others. So I put, it's all very important, but this is the declaration of legislative purpose. So why do we have this guardianship statutes? And this on number 3, to this end, guardianship and conservatorship for disabled persons shall be utilized only as is necessary to promote their well-being, including protection from neglect, exploitation, and abuse, shall be designed to encourage the development of maximum self-reliance and independence in each person, and shall be ordered only to the extent necessitated by each person's actual mental and adaptive limitations. So in many cases, you could say that really you should be exploring alternatives and what people's strengths are before we go down the route of looking at guardianship. So how is a person declared disabled? Petitions are filed in district court. There's a petition, an application. The judge then appoints the counsel, and it goes back to the point that we were talking about earlier. There is some discrepancy in terms of, is it a guardian ad litem or is it actual appointed counsel for the respondent? Our office believes it is actually appointed counsel for the respondent. We do agree that maybe the legislature, hopefully in the future sessions, could maybe work together to maybe clarify that so that it is very, very clear and that it is appointed counsel. So I think there could be a little bit work done in terms of advocacy from various organizations and individuals themselves to just clarify this. So maybe that would help in the future with some of these appointments. I think if, especially when we're looking at the public guardianship system, many of y'all may have interacted with them, or maybe you've been a person under guardianship, but it's 4,500 people, I think, to 4,700 was the last count of individuals under state guardianship. I believe, and there may be somebody from Dale on the line, I believe it's 60 individuals per field worker. So it's a very overburdened system.
Yeah, I think it's 100.
I think some of them have, that's not the average. Yeah, I think that some have an upper limit of around 90, but I think if you're looking at average, I think the last average I heard was, it's still a lot of people. Because I know that I think the standards they usually say, I can't remember, but it's half of that at least.
In a lot of states that have state guardianship, not every state does, but a lot of states that do limit the number. I think it was Virginia, I think recently limited theirs to 20.
For caseload.
For caseload, I think
yes.
we have a question.
Online, Bill Schultz says, I was with Dale yesterday, and it's about 80 per caseworker.
Okay.
Most states are 25 per people, per person.
Okay, well then that's gone up since.
Yeah, so it's a lot, and they recognize that it's
right.
overloaded. It's not a.
So I feel like if we could clarify, in the court system, even this appointment of counsel, that could be a great effort to prevent some of these appointments. Yes.
Bill Schultz says Indiana and Virginia have 750 total. Kentucky has 4,500 plus.
Yeah. Okay. Okay, 6-person jury trial or bench trial. This is one of the changes in House Bill 5. If any of you all followed the legislation last year and some of the changes they made to guardianship, this is one of the changes where we've always had a 6-person jury trial. In fact, PNA has testified and advocated for that to remain over the years. However, this year House Bill 5 was passed, which include that if all the parties agreed, then they could opt for a bench trial. So, and a bench trial means the judge makes the decision. Essentially, they sit on a bench, and that's why they call it a bench trial.
Did House Bill 5 pass?
Yes, yes, these are current. Yes.
Tim Feely says, the new law asks judges to consider public guardianship workloads.
Yes, that is part of House Bill 5 changes too.
Deputy Secretary Field.
I think, and I believe we have a slide that talks a little bit more about the House Bill 5 and what some of those changes were. It's further down.
Is there a particular definition of disability that they're using when they're trying to decide whether to declare someone disabled or not?
Yes, but I don't.
I'm trying to recall.
They're all those terms are defined, but I don't remember how they define it. But it is different. You're not defining someone. You're finding them legally disabled, as opposed you could have a disability and not be legally disabled. If that makes sense.
That's probably interesting to see what
The definition
There
is.
a definition.
Well, and I can look that
Bill
up.
Dolan, can you Google that for
Yeah.
us?
Look that up. Disabled definition. Yeah, because so this next part is how they determine if you're disabled or not disabled. So the judge, after the filing of the petition for a person to be considered for guardianship, 3 persons are identified as the IDT team, the interdisciplinary team. This is another change, a small change to House Bill 5. They added a PRN or a physician assistant to be able to also be part of this team. Before it was just a physician. So the judge will appoint a physician, a psychologist, and a social worker, and they will determine, that's their charge, is to do an evaluation and assessment to determine if you're disabled or not disabled. And I believe there is an actual assessment that they utilize to make that determination. I think a lot of that makes it, that's how they come to the determination or the conclusion if they're disabled.
And the end of that form that they all have to fill out, or I don't know if it's the end, but it's somewhere in there. It actually asks if alternatives exist. And I've almost always seen it checked no or just skipped.
Right.
And it's on there.
So at least one person must be a professional qualified in intellectual disability or mental health, depending on if the respondent has an intellectual disability or a mental health diagnosis.
Question.
Yes.
Bill has found the answer.
Thank you, Bill.
Disabled means a legal disability, not a medical disability, and it is measured by functional inabilities. It refers to any person 17 years of age or older who is unable to make important decisions with respect to his personal affairs to such an extent that he lacks the capacity to provide for his physical health and safety, including but not limited to healthcare, food, shelter, clothing, personal hygiene. And there are a couple other.
So if you want to think about that, that's actually kind of a scary definition because
Yeah.
a lot of us could fall under that.
Well, and that's why you get a lot of evaluations that I've read and that I know Kevin has read, where I know the person and I would have come to a total different conclusion than the person, the social worker or the physician that actually did the assessment. And I think because that is pretty broad, and how do you come to that determination? That's another issue. But
Unable to make important decisions with respect to his financial resources.
that would be you.
That'd be me.
That would be Laura. So the hearing within 30 days, if evaluations are filed with the petition. So they would have a hearing within 30 days if the reports are filed with petition. That very rarely happens. So otherwise within 60 days, because usually, and often I've even seen where they've had to actually do a continuance because the IDT reports were ordered, but the members of the IDTs were not able to meet and assess the individual, the respondent. So sometimes we see those even further, but by, the law says within 60 days or 30 days of filed with petition.
And in a lot of counties, you get one psychologist and one social worker who do
them all.
most of them, if not all, yeah.
The respondent must be present unless the court determines the attendance would subject the person to serious risk of harm or fails to appear. This has been one of the issues that we've had over the years. We talk to a lot of persons under guardianship, and we'll ask them, well, what happened at your hearing? And they're like, what hearing? I didn't have a hearing. I didn't go to my hearing. Well, we often find that individuals are under guardianship and they did not appear at their hearing, nor did they even know about their hearing. So the hearing, part one, jury trial, bench trial. So we advocate for the jury trial, but it could be a bench trial. After House Bill 5, the possible outcomes: not disabled, or partially disabled. So then the judge will determine the type of guardian, whether the guardian or partial guardian over personal affairs, or the conservator or partial conservator over financial resources, and then the individual or entity appointed and duty. So whether it's a family member or another interested party, or if there is no one else who is willing to be the guardian, then at that point, that is often when Dale is appointed or state guardianship, and then the person's rights are taken. One note on this too, and I think we talk a little bit about it in a couple slides on down. I think around 2007 or 8, there were some changes in the law in terms of the voting right. That now is that right is determined strictly by the judge. They will make that determination on whether or not that person has a right to vote. It's looked at very separate from all the other the rights. And we actually see now new appointments. We see more likely than not you're going to retain your right to vote. So I think that's a positive thing.
And if you were, if guardianship was appointed prior to that happening, or even since, you can still petition to have that specific right restored. And somebody asked this question the other day, and I think at this point it might be too late to get that. If you haven't already initiated, it might be too late to get it and get it done in order to get it so that you could vote in the next election. But it's good to be thinking about it if that's something that you want.
And if you are a person with a disability who does not retain your right to vote, or you know of someone with a disability who would like their right to vote that currently does not have that right, feel free to contact P&A, and we can provide technical assistance, or we can assist them in that process. So please reach out to us if you know of somebody who's interested in voting and exercising that right. Okay. So the duties of guardian and limited guardian. Going back to limited guardian, Laura, you have NCI data, and is it accurate to say that based upon your NCI data from a couple of years ago, that only 3% of individuals, according to your data, have a limited guardian versus a plenary or a full guardian?
Yeah, only 3% of people who have a guardian have limited guardianship. So everyone else is full.
So, Kentucky. And
it's pretty close to that nationally too. I can't remember the specific percentage, but it's 3 to 5, something like that nationally.
And just knowing a lot of the folks who are under guardianship, because I work with people daily under guardianship, a lot of them probably partial guardianship would be more appropriate. So that's something to think about as an advocate that's listening here today, that you could be advocating for on behalf of yourself or others when they're going through this process, is to really advocate for utilizing that option. I think sometimes I think judges and attorneys, they just automatically do full plenary guardianship, and we just don't think to explore. So I think really promoting the use of that more often could actually have a great impact, positive on not only the system, but the individual themselves, and empowering them. And then we might see better outcomes, life outcomes. And then hopefully, and like Laura said, the great thing about that limited guardianship is it's 5 years. And it's automatically going to be looked at by the courts.
Or it just terminates.
Or it just terminates, right. Which we love too, because a lot of times the person that may have been the guardian, they're doing great now. There's no reason, and so there's no reason to petition, to renew. Right.
Right.
Sorry.
And because of limited guardianship is underutilized, but it is used some, which is why it's important if someone tells you they're a person's guardian or a person says they have a guardian and you're working with them in a professional way, make sure you get a copy of the order so that you know that, A, the person actually does have a guardian, because substitute decision making is a problem even for people who don't have guardians, and that it is a full guardianship, or what that guardianship might cover, just so you know so that everybody knows what is actually happening legally.
So this is the Kentucky Revised Statute for Duties of Guardian and Limited Guardian. And again, these are, it's a lot of words on a piece of paper, but they're very powerful words. And they're words that I often use when I'm talking to advocates and persons with disabilities, when I'm working with them on how to advocate for their rights within, if they are a person who is under guardianship. So the duties of the guardian are to ensure the personal, civil, and human rights are protected. They should be encouraging the ward to participate to the maximum extent of their abilities in the decisions. Act on his own behalf on all matters which he is able to do so. And then I realized like a couple of days ago, I probably need to highlight some of the red in C too, because that is develop or regain to the maximum extent possible the capacity. So the guardian should actually be working with the individual to help them regain the capacity to make certain decisions.
Like using supported decision-making to develop your decision-making skills.
So again, this is another Kentucky Revised Statute, the specific powers and duties. I like this one because it talks about how they are to make provisions for the person under ward's care, person under guardianship's care, comfort and maintenance, and arrange for educational, social, vocational, rehab services. We get calls often from individuals with disabilities or other maybe supporters of them, and they're like, Jane wants to get a job, but her guardian says she can't have a job. She can't go to work. We can't even send a referral to OVR. Well, this right here is what I utilize when I'm communicating on issues of that nature. I often would, tell the advocate to, utilize this language, because the statute says they should be making provisions for educational, vocational, and rehab services. Specific powers continued. To act within respect to the ward in a manner that limits the deprivation of civil rights and restricts his personal freedoms only to the extent necessary. So the way that people should be making decisions. They should be allowed to do things they want to do, as long as it doesn't impact them to where their health, safety, welfare is in jeopardy. Voting rights. No longer automatic loss of voting rights. We've already talked about all that. So we've talked about this. So if it's a full guardian, it's forever unless an interested party petitions to have it modified or terminated, and you're successful. And yeah, I had a case in, it's been a decade ago at least, but I won't say the county, but where I assisted a young man to get his rights back in a small county, and the county attorney was like laughing at us, and he was just like, Judge, I don't understand why we're here. We don't help people get their rights back. We just take them away. So that's a good example.
We've heard that since too. That's a prevailing thought.
So
in particular case we're on.
So it is concerning, because if it's full guardian, we don't know. I mean, we can't assure people that what's going to happen in courts. We don't have any control over the outcome of the court. But that's what's great, again, about the limited guardian, where it expires in 5 years and unless it's looked at to be renewed. How to change or end guardianship. So this is done in the county the district court that the individual resides in. Even if the appointment is in Jefferson County and I live in Pulaski County, they should still file in Pulaski County. Now, I'm not going to tell you that that's all going to work out smoothly and that the clerk's offices aren't going to say you can't do it that way, because we do find that every county kind of does things a little different, and some of them may not be aware of the regulations or statutes. And so sometimes we have to kind of educate them on what those statutes, what those regulations say. But it should work that you should file in the county that the person resides in. Those are questions that if you're having those issues in particular counties, if you all contact us, we can try to advise you. So at any time, the ward's guardian, any interested party can petition to terminate, replace, remove, renew. The process is there is an Administrative Office of Courts form, the 795, that is the petition to modify, terminate. So you complete that form, file that in the district court. At that point, appointed cancel you should receive appointed cancel. Or most often you're appointed cancel. And then the judge may choose to get new IDT reports. The judge, I've seen where sometimes the judge does not request any new reports. Sometimes it's 3 new reports if it's been a while. And sometimes I've seen, well, we just need to get a social worker or psychologist report. So it really just varies from county to county on what that process may look like. Normally an appointed attorney is appointed, but I think Susie's case is a good one to show that it doesn't always happen. And as I recall, it's not necessarily in statute that in the modifications, and Bill can correct me if I'm wrong, that they're automatically appointed, but normally they are. And if you request, if for some reason you're not appointed cancel, then, I just suggest that you ask the judge to appoint cancel. And I would hope, I've never heard in any case where that's been denied, but I'm sure there's cases out there like that. The state guardianship. I know Department of Aging and Independent Living is on the phone. We have, I believe, Judge Feely and a couple of the guardianship field staff and supervisors. And so now we're talking about you all. So you all are administered by the Cabinet for Health and Family Services, and your agency is Department of Aging and Independent Living. So the Division of Guardianship can function as a guardian, conservator, limited guardian, or any combination. So here are those changes to House Bill 5 that impact state guardianship. So again, we're talking about state guardianship here because I know I've watched some people, when we've talked about this recently, there's been some confusion. So I just want to emphasize state guardianship. So the potential ward now must be a resident of the state for 6 months, cannot have a sex crime or violent offense, must be alive and able to physically be located.
Which was put in there for a reason, because it was happening.
The duties and responsibilities are limited. So they do not have to assume physical custody, cannot be caregiver or custodian, not physically responsible. And Dale does, one of the responsibilities to procure resources and services for the individual that is placed under guardianship. So those are some of the changes to House Bill 5. So the next couple of slides, this is the state guardianship regulation that I often refer to when I'm working on different cases. And this is the decision making on behalf of a ward. And this is basically guidance to help Dale staff make decisions on behalf of those that they represent or they are guardianship of. So informed consent, substituted judgment, best interest, and less restrictive alternatives. Here is another regulation, Kentucky Administrative Reg, and this is the field service branch, so that's Dale. It shall use the guidelines of making decision on behalf of a ward. So you all have this slide. I won't read this all to you, but this is again more guidance on how they are making decisions on behalf of individuals under guardianship in the state of Kentucky. More. Okay, the field service branch shall consider the least intrusive, best interest, and least restrictive alternative. So the next question, and we're doing good on time. So how can I advocate for someone's rights who has a guardian? So we get a lot of calls, and so these are what we tell them. Well, we try, and that's one of the purposes of today is I'm trying to educate people, and Laura's trying to educate people on alternatives and what the laws say in terms of what the roles of guardianship is, and then also about alternatives. Ask questions. If you are a person with a disability and your guardian or providers are saying you can't do this, you can't do that, ask why. Ask the questions. Understand why they've come to that decision. Educate individuals about their rights. And then if you have somebody who continues to advocate to be able to do certain things or to have certain rights, but you're unsuccessful, you can always provide our information to individuals, and they can call us and we can provide some technical assistance to them. And then any interested party can call P&A. Anybody can call P&A. So if you are working with someone either as a provider or you're a family member and you have questions because you think that guardians are either they're not following what the law says they should be doing, or you have other questions related to even outside of guardianship, abuse, neglect, exploitation, or anything else, just call P&A. That's what we're there for. And at the end of the day, I always say you can go back to district court. If a guardian continues to what you believe to violate what the statutory and regulatory language is on how they should be making decisions on behalf of wards, go back to district court. A petition can be filed, and we'll let the courts work and handle that. And this is applicable, and this isn't, I'm not just talking about Dale here, please understand that. This is all, I'm talking about guardianship, period. Anybody who has a guardian, this is appropriate answers for all of those.
So this is just a review of the some of the national parent indicators data that we've already referenced. So 61% of the people surveyed had full guardianship. 3% of those, 3% of people had limited guardianship, and then this is interesting that 43% of people who were identified as having a mild intellectual disability had full guardianship. And the issue with that is that when we're comparing those folks with mild intellectual disabilities to each other, you take a group of people who don't have a guardian, take a group of people who do. People who don't have guardians have higher rates of employment, are more likely to report having friends and family friends who are not staff or family members, and a lot of other life outcomes that we look at. They tend to be more positive, looking just at that group of people reported as having mild intellectual disabilities. So it's a lot of people. You can see why Dale's overloaded, because a lot of those people don't have it here, but we do have the statistics about how many of those people are state guardians. It's a lot of people, and well, we know some people who don't need to be there, and we've talked to field workers who have people who they do not believe need to be under the state's care. And
we're certainly happy to look at some of those cases.
Yep.
Judge Feely.
Question?
Judge Feely says one correction to your slide that says the public guardian is not fiscally responsible. That protects individual guardians from personal liability unless grossly negligent. It does not mean they're not fiscally responsible for safeguarding the ward's assets.
Right. I think what we're trying, and we can change this to be more specific, but it is to ensure that the liability doesn't fall on the guardianship system or the guardian themselves. Because, like, for example, if they do substantial damage to property, or there are certain expenses, credit cards, something of that nature, that doesn't fall on the state or the individual field worker to be responsible for. That's what the intention of that, but thank you for clarifying, and we'll try to make that more clear in the future. Thank you.